U.S. Supreme Court Justice Sonia Sotomayor gave the government until Friday, as Colin just said, to respond to her temporary halt of a key provision of the Affordable Care Act. The provision in question would force some religious-affiliated organizations to provide health insurance for employees that includes birth control coverage. Constitutional law professor Kermit Roosevelt is with us, and he teaches at the University of Pennsylvania, and he's joining us on the phone. Thank you so much for being here with us, Professor Roosevelt. I do appreciate it.
Thanks for having me.
I think I want to start with the basics first, and that is explain to us why Justice Mayor ruled on this individual, not why this was not a panel ruling, and why the Supreme Court as opposed to a lower court.
Well, what's happening here is each federal circuit, which is a distinct region in the country, has one justice who acts as a supervisor for that circuit. And people who have cases going on in that circuit can ask the justices for temporary relief from an order from another court. So the plaintiffs here, the Little Sisters organization, like many religious organizations around the country, they're challenging the mandate, that's one thing, but they're also asking that it be suspended while their case is being heard. And that's the kind of issue that Justice Sotomayor got involved in. What she said was, government, you can't enforce this against this organization until there's a final decision. So she actually didn't decide in any ultimate sense, is this law constitutional? Can it be applied against these people? All she said was, until the case gets decided, and this is something that one justice can do on her own, until the case gets decided, it's not going to be enforced unless actually the government convinces her otherwise. So the stay that she entered lasts only until tomorrow. The government's going to respond, she could lift it.
And speaking of which, that's right, this only lasts until tomorrow. So in effect, she's forcing the court to make a ruling. What's the chance that that they will?
Well, she's not really forcing the court to make a ruling. I mean, I think probably she's going to leave the stay in place while the litigation goes on. Eventually, the Supreme Court will decide the ultimate question, you know, is this law constitutional? Can it be enforced against these people? But all she's doing is sort of preserving the status quo until that happens.
So let me ask you this, Kermit. Of course, the Obama administration has already said that women who work for nonprofit religious organizations that object to covering birth control can receive coverage elsewhere. So can you sort of explain why these sisters in California felt the need to bring this suit when there seems to be relief for employees who want this coverage in a different way?
Well, the mechanics of the statute are very complicated, but the claim that the Catholic organizations are bringing here seems to me quite an extreme one, because they are not, as you said, being required to take contraceptives. Certainly, they're not being required to provide contraceptives to their employees. They're not being required to provide their employees with money to pay for contraceptives. All they're being required to do is to say, we don't want to cover contraceptives, and then, under the terms of the law, someone else will step in and doing it. But what they're saying is that even doing that, even saying we don't want to so someone else has to, that is a burden on their religious beliefs.
This ruling is very narrow, but can you sort of tell me what the ripple effect of this issue is?
Well, the ripple effect of this issue is it's one of the big questions, you know, when religious organizations don't act just as churches, when they go out and they conduct, you know, when they're a hospital or when they're a school, when they provide various kinds of services, do they have to play by the same rules that other businesses do? And it's not entirely clear what the answer is. This law tries to make a lot of accommodation of religious beliefs. So it definitely does treat religious organizations differently than other ones. The problem from the religious perspective is it doesn't do that far enough.
And let me ask you this, because as we know, and we reported here on Arise America, that there is already a case before the Supreme Court that is on their roster for this session involving Hobby Lobby, which is owned by a Christian as well as another organization. I'm looking for the name of it. It's a woodwork organization that have... Sorry?
Yeah. Yes, Conestoga Woodworks, I think.
Right. So how will, I guess, what is the connection between these cases? Will the suit that is already on the roster that is being considered and has already been argued, as I understand it, will it have an effect on the ruling of this lower court in this specific case? Is there a connection, in other words?
Yes, there is a connection. You have a lot of different groups around the country bringing very similar challenges. Now, in some cases, they've got slight differences, but they're all presenting the same basic question, which is to what extent can this requirement be applied to religious organizations? So the Supreme Court is eventually going to decide it for everyone, probably in one case.
I also understand in some of the reading that I did that Sotomayor denied a request for an injunction from Hobby Lobby in the same issue in December 2012, which seems to be the exact opposite of the action that she's taken here. What's the difference there?
That's not entirely clear. It might have been that the way in which the law applies to a larger chain of stores like Hobby Lobby is different from the way in which it applies to a smaller organization like the Little Sisters.
Mm-hmm. What do you suspect, even looking forward, when the results start to come down in late spring, early summer from the Supreme Court ruling in this particular case? Where's the trend going? What do you predict will be the outcome?
Well, in most of these cases, the courts have split, but in most of these cases, the religious plaintiffs have lost. And I think that's what the Supreme Court is going to say. Now, it's difficult to predict what the Supreme Court will do, and with the Affordable Care Act, many constitutional law professors have been wrong before. But my guess is that they're going to say the law makes a sufficient accommodation for religious belief. The Constitution doesn't require anything more than what the government has done here.
Yeah, it's a very controversial, emotional, and complex issue. Kermit Roosevelt, thank you so much for taking some time with us.
Thank you.